Rule 116, Arraignment. What is arraignment? Arraignment is the formal mode of implementing the constitutional right of the accused to be informed of the nature and cause of accusation against him. Is it mandatory? Yes. Arraignment of the accused is mandatory and his presence is required during arraignment. Actually, there are three instances when the accused presence is required. First is during arraignment. Second is for identification purposes. And third is during promulgation of judgment. Does the accused can be absent during trial? The answer is yes. Actually, we have discussed that in Rule 115, rights of the accused, that the accused may be absent during trial if it is stipulated in his bail, if he was absent during trial without justifiable reason, or when the accused has escaped from confinement, then his right to be present during trial is actually waived. So before arraignment, there are several duties by the court. One of the duty of the court is to inform the accused of his right to counsel and ask him if he want to represent himself without assistance of any counsel. When can the accused represent himself without assistance of any counsel? If first, upon motion, and second, when the court is of the opinion that the accused can properly defend himself by person. If the accused wanted to be represented by a counsel, he may choose a counsel of his own choice, the counsel de parte, and if he has no counsel or he has no capacity to obtain the services of a counsel, the court shall appoint counsel de officio. And once the counsel de officio was appointed by the court, that counsel should be given a reasonable opportunity to converse with the client and to properly prepare their defense. Is there any instances when a person cannot be represented by a member of the bar? Yes, actually in provinces where there is no present member of the bar, meaning there is no lawyer, the court can appoint a person of good repute, of probity and ability to present the accused or defend the accused. Okay, how the arraignment is made. In section 1 of Rule 116, it is said that the accused is arraigned in the court, in an open court actually, where the information or complaint is filed. It is done by the judge or the clerk of court, furnishing the accused of a copy of the complaint or information and reading it in the dialect known to him and asking him whether he plead guilty or not guilty to the offense charge. Also, the both arraignment and plea shall be made of record, but failure to do so shall not invalidate the proceedings before it. Next question is, what should the court do if the accused refuses to plead or make a conditional plea? In letter C of Rule 116 Section 1, it is said that when the accused refuses to plea or when the accused entered a conditional plea, the court shall enter a plea of not guilty for him. And in cases also when the accused pleads guilty but he presents exculpatory evidence, the court shall enter a plea of not guilty for him. Next question is, what if or what is the period of the arraignment when the accused is detained? When the accused is under preventive detention, his case shall be raffled and the records of his case shall be transmitted to the judge selected by the raffle, and the court within 3 days from the filing of the complaint or information. Then after 10 days thereafter, the accused shall be arraigned, and then 10 days thereafter, a pre-trial conference shall be held by the court. Next question is, when the presence of the private offended party is needed. Okay, we said earlier, or we already know that in criminal cases, the real offended party is the state. And the case can actually proceed without the presence of the offended party. But when is the presence of the offended party required? First is the presence of offended party is required, one, for purposes of plea bargaining, second is for the determination of civil liability, and third is for other matters requiring his presence. So, is there a necessity that the accused shall be present absolutely during plea bargaining? The rules of court provides that no, the accused may also be absent, or the failure of the accused to be present during arraignment with due notice to the offended party will entitled or will allow the accused to enter a plea of guilty to a lesser offense necessarily included in the offense charge only with concurrence of or consent of the trial prosecutor alone. So for example, the accused is charged of the crime of murder, but the private offended party is not present during arraignment. At the time, the accused can still plead guilty to a crime of homicide, and it will only require the concurrence or consent of the trial prosecutor. Next is, what is the other period for arraignment? Okay, what is the period for arraignment? Arraignment shall be held 30 days from the date the court acquired jurisdiction over the person of the accused. Having said that, when is the jurisdiction of the person of the accused is obtained by the court? The first is by arrest, and second is by a voluntary submission to the jurisdiction of the court, by voluntary surrender, or by actively participating during trial. Next is, before arraignment, what are the options available to the accused? First, he can file a motion for bill of particulars. When he thinks that there is defect in the information, it does not sufficiently alleges the acts or omission complained of, then the accused may file a motion for bill of particulars to properly prepare his defense. He may also file a motion for suspension of arraignment. He may also file a motion to quash, or he may challenge the validity of arrest or absence of the preliminary investigation. We know that before trial, arraignment has to be made. But what if the case is already submitted for decision? Can there still be arraignment? The answer is yes, if the accused did not object to the continuation of the proceedings, even he is not arraigned, that is constituted waiver of his right to arraignment. Actually, if he actively participated in the trial, it is presumed that he already is informed of the nature and cause of the accusation against him. We said earlier that an accused pleading guilty to a crime, to a lesser offense necessarily included in the crime charge, shall need the concurrence of both the offended party and the prosecutor. The exception to that is when the offended party is actually absent during arraignment. There's only necessity for the consent of the trial prosecutor. But can the accused still plea for a crime of lesser offense, or for plea guilty to a lesser offense, if the prosecutor has already rested its case? That is answered in the case of Daan versus Sandigan Bayan, and the court held that yes, It may also be considered during trial or even after the prosecution has finished presenting its evidence and rested its case. It is immaterial that the plea bargaining was not made during the pre-trial stage or it was made after the prosecution already presented several witnesses. Okay, what will happen if the accused plead guilty to a capital offense? So what is the capital offense? That's death. The death penalty is the capital offense. Although it is suspended now, there is no death penalty now. What if the accused pled guilty to a capital offense? What is the duty of the court? The duty of the court is to make searching inquiry to the voluntary. So, the full comprehension of the consequences of his plea. It may also order the prosecutor to prove his guilt and the degree of culpability and provide evidence to the degree of culpability. What if the accused plead guilty to a non-capital offense? What is the duty of the court? The court shall require the parties to present evidence to determine not a degree of culpability but to determine the imposable penalty, or the penalty to be imposed. Imposable penalty and penalty to be imposed is different. Okay. What if there's a withdrawal of improvident plea of guilty? When can it be done even after arraignment? Yes, improvident plea of guilty can be withdrawn even after arraignment but before judgment, and in that case the plea of not guilty shall be entered for the accused. Okay, we already talked about bill of particulars. Next is the modes of discovery. Is there modes of discovery in criminal cases? Yes, in rule that can be found in Rule 116 Section 10, it is provided there that upon motion, upon good cause shown of the accused with notice to the parties, the prosecution may be ordered by the court to allow the inspection, the copying, photographing of any statement of a witness or the complainant which is under its custody, or also the letters, photographs, objects, or tangible things not privileged which constitute or contain evidence material to any matter involved in the case, which are in the possession and control of the prosecution, police, or other law investigating agencies. What are the grounds to suspend the arraignment? First is when the accused is suffering from unsound mental condition and he cannot understand the nature of the and cause of the accusation against him, and he cannot also plea with intelligence or provide a proper plea of guilty or not guilty. Second, when there exists a prejudicial question. When is there a prejudicial question? The requisites are: there is first filed civil action. The civil action is first filed before criminal action, and that the determination in the civil action is necessary to determine whether the criminal action shall proceed. The third reason for suspension is when the petition for review for the resolution of the prosecutor is pending before the Department of Justice or the Office of the President, provided that the suspension is not beyond 60 days from the filing of the suspension, from the filing of the petition for suspension. Okay, I think that's it. We already tackled Rule 116 arraignment.